Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so that I can answer your questions. So I just want to focus on your questions today. So just go ahead, put your questions in as soon as you know your question. If you were on the live with me yesterday, you had your question, you didn't get the answer, now is the time to put it in because I'm going to go through and only dedicate the time to questions. I did have one thing. So while your questions are coming in, I did mention yesterday, hi there, Kisan. Kision. I did mention yesterday that I wanted to talk about the stepchild relationship, step parent, stepchild relationship, and how one can get immigration benefits through that type of relationship, because maybe not a lot of people know about this. So if you are the step parent of a US citizen and that US citizen is 21 or older, and that when as a step parent you married the parent of that citizen child before that child turned 18, that US citizen child can then petition for you as an immediate relative of a US citizen. That means you have a faster process, just like the a biological or an adopted parent of a US citizen age 21 or older would have. The other is if you are the son or daughter of a US citizen and you're under the age of 21 and your parents got married, so your step parent and your parent got married before you turned 18, then they can also petition for you to get your papers. But it doesn't stop there. And by the way, the step parent stepchild relationship, it extends to permanent residence as well. But when you're the parent or you're the child of a US citizen, then in that process you're considered the immediate relative of a US citizen, so it's a faster process. With being the step child of a permanent resident, which has the same definition, your permanent resident step parent would have had to get married to your parent before you turned 18 to qualify here. But when you qualify, you do have to wait for your priority date to become current. So that's the only thing. The priority dates don't apply to step parent, stepchild relationships as immediate relative category, but it does apply in other categories, right? The priority date. So now, not only does it stop there, but if you have been mistreated by a step parent, you're still under 21 or you're under 24, you can apply for VAWA. If you're the step parent of a US citizen who's age 21 or older and that stepchild mistreated you, you can qualify for VAWA. That means it's your process, you apply for it based on the mistreatment. So this is what I wanted to point out. I am very experienced with this, and I just got notification 2 days ago. My client has been approved based on this type of situation, being the stepchild of a US citizen and stepchild based on immigration law. So that's what I wanted to point out. So if you're in a step parent, if you have a step parent or you have a stepchild, you are looking to see if they can petition for you or if you can apply for VAWA, give me a call. Let's talk because it may be possible. Now to questions. Let's get to questions. I'm going to scroll through very quickly. So I'm trying not to miss any questions here. If I get my application for VAWA, can I still live with my wife? Yes. So I have applied for VAWA for my clients who still live with the spouse who's mistreating them. These are complex situations, and not everybody is ready to just walk away from mistreatment. Sometimes it takes a while. Keep in mind, in these kinds of situations, in situations that can be categorized as domestic violence, for example, uh, it does take an average of 7 times for that spouse to leave, 7 times before they can make the final decision to walk away. But that does not mean that they still don't deserve help. And maybe a part of this help is to have an exit plan. And applying for VAWA can provide them a safe exit plan, because if you're applying for VAWA, that means that you can get your work permit, you can get your green card to empower yourself to finally escape the situation or leave the situation. So, absolutely, you can apply for VAWA even while you're still living with this person. Um, so, definitely get the help. That's priority here. Your safety, your well being, and exit plan, those are priorities. And VAWA is a part of that plan and process. Are you in Brooklyn? So I am not, I don't have a physical office in Brooklyn, but keep in mind, the way that my law firm works is we represent clients all over the country and the globe. And we do it right here in Boca Raton, Florida. And we've not had any issues with this. We've been very successful. So even if no matter where you are around the world, in New York, in another state other than Florida, if you're 100 miles from us, if you're 1,000 miles from us, we can still represent you. And now keep in mind, as an immigration attorney, we practice federal law. And what that means is that we don't have a restriction on the state, because we are representing our clients before a federal agency, which is national. So there are no borders when it comes to practicing this type of law. Okay, so my wife and son were filed for together, but mom got through, son is still outstanding. So it really comes down to what's going on in the case. Is there anything missing from your son's case? It comes down to communicating with wherever they are, if they're at the NVC or if it's at the local USCIS office, possibly communicating with them to figure out what the issue is there. What about your mother-in-law mistreating you? So, unfortunately, that's not covered under VAWA. However, anytime there's any kind of mistreatment or abuse, I evaluate all options here, because that, for example, say you're living in the mother-in-law's house, the mother-in-law starts to force you to cook, to clean, to work in the house, maybe even work in a business, forces you to go out there and then takes your money, things of that nature, then that could possibly fall under the T status, where you can still get relief that way. And then another question here is, your mother-in-law is mistreating you, but where's your spouse in all of this? Why isn't your spouse backing you up here? So I would want to know more here to evaluate your options, but there may be alternative options when there comes to abuse or mistreatment by other people. My wife and son, okay, so I answered that. 30 plus years undocumented, married to a US citizen 6 years ago. Can I apply for the green card? Now, undocumented is a very general term. And anybody who has overstayed, who has crossed the border without permission, can be defined as undocumented. The thing about this is, if you cross the border without permission and you have a US citizen spouse, that still does not mean that you can apply for adjustment of status while being here. If your spouse is mistreating you, then you may qualify for VAWA. But if you're looking for your spouse to petition for you, but you cross the border without permission, adjustment of status is not going to be permissible in a case like this. unless, of course, you're applying for VAWA. There's what's called the I-601A waiver process, which doesn't allow you to stay here. I had a work permit under asylum. Case is closed. Now I'm under visa, on the U visa. So yeah, so I guess you've applied for the U at the same time as the VAWA, as in addition to the asylum. How long does work permit of 150 extension take after submitting the application? It depends on what kind of application. So I've seen them range from 3 months to even 12 months. When you're doing VAWA in New York, how long does it take to get your green card? So it's filed and it's processed at the Vermont Service Center, all VAWAs. And right now they've also divided that work with the Nebraska Service Center. So it's actually not processed in New York. But once your VAWA petition is approved and they're now looking to grant you the green card, it may go to the local USCIS office for an interview or for them to make a final decision on the green card at that stage. But first, you have to get through the VAWA petition, which is filed at the Vermont Service Center in Nebraska. Can I do biometrics before getting married? No, so you have to wait for them to send you the biometrics notice. Could I get work permit if we're married, but our case requires joint sponsorship? So if you're filing for your adjustment of status, you may still be issued the work permit while you work through your affidavit of support process. For I-130, is there a third interview after the second interview? There may be if they still have questions, but you definitely have something to worry about if they're giving you a third interview. The second is usually called the Stokes interview, which usually means that they suspect some kind of fraud and they want to see if your marriage is real. And this is, by the way, if you are in the United States. And maybe even at the embassy, right? Because they usually do one and one is enough. So if you have two, you definitely need to be concerned at that point. Three, yeah, they're digging. Can I do, it's normal for a work permit for adjustment of status. It's taking more than a year. Is it normal? So it's not, no, adjustment of status if you're applying through VAWA can take up to a year. If you're applying through marriage base, it usually takes 3 to 6 months, sometimes a year, just depending on what's going on in your case. Is it true that now they're going to waive the fee for I-485 through VAWA? So no, that's not true. Is it beneficial to file I-824 when or before filing for humanitarian reinstatement? So you have to first get it reinstated before you can file anything else. Can a former U.S. military contractor use that to file a green card? I'm not sure what they can use. Can a green card holder file for their kids in Jamaica after you be a citizen? A green card holder can file for their children, unmarried children, at any point. You can apply for your children, of course, once you become a citizen, but what's keeping you from applying now? Because applying now could mean that they could get through even before you become a citizen. So it just depends though on what your circumstances are. How many petitions can a person have? It depends. There have been, people can file multiple petitions for different things, but is it advisable? Is there a strategy behind it? That's where you have to make sure you have legal representation, because if you have multiple petitions, are they conflicting? Will they cause a problem here? It may cause a problem, but it may not, because I have filed multiple forms of relief for my clients at the same time, but we know it doesn't conflict at that point. After biometrics appointment for your green card, married a U.S. citizen, what's next? So usually after that, you'll get your work permit and travel document if you applied for it. How long does it take? Can your husband use your ITIN to file for you, even if you've never used it before? So ITIN is the ITIN number. I don't know if you're talking about taxes. It's there to file taxes. It's not there for filings, immigration filings. So something seems off there. Can I do an I-130 for my mom? I'm a US citizen. She left 13 years ago to Mexico, no deportations. Sounds like there's something more complex here. So if your mom left 13 years ago, was she barred for the 10 years? If 13 years have passed since she left and since the bar went into effect, then yes, there is a possibility that you could apply. But I'd like to hear more about your history before I can advise you personally. Because remember, none of the information here is personalized legal advice, it's general information. Our VAWA fee is going to increase on the 1st of April as well. So VAWA is $0 for the VAWA petition. But when you're applying for VAWA and you can qualify for adjustment of status at the same time, then you're going to have to pay the adjustment of status fee, which is going to be $14.40, I believe. So I have to pull the schedule here, but it's $14.40 after April, on and after April 1st. Do you need a financial sponsor when applying for green card through the T status? So no, this is your process, and you are exempt from, public charge considerations. What if I'm working on B1, B2 visa and I want to do the T visa? Is that going to be a problem? So this is where you need to get legal advice. They don't conflict. So the T visa and the B1, B2, they don't conflict, but this can raise more questions for the consular officer that's evaluating your B1, B2. So you want to get some legal advice to see if that's possible. My wife just decided that she wants a divorce and she's yet to give me a reason, decided no, she no longer wants to file with me. So let's talk, because I would want to know more about what was the pattern of behavior of your wife towards you before telling you she wants a divorce. Because in some cases it does amount to extreme cruelty or mistreatment. But just because a spouse says they want a divorce, and maybe for no reason, it's not enough. That in itself is not enough to go and file a VAWA. There has to be a form of mistreatment going on. So if you feel like you have been mistreated by your spouse, that's a good starting point to get legal advice and get going on the VAWA process if you qualify. But I need to talk to you to determine whether you qualify. For immigration benefits, or based on what USCIS get convinced. So I think this is approval for VAWA, and you do have to present credible evidence. That means believable evidence to show that you have been mistreated by the qualifying relatives under VAWA. So that's the spouse of a U.S. citizen or permanent resident that has been mistreated, the child of a citizen or permanent resident, or the parent of a U.S. citizen, or step parent, as I said earlier, of a U.S. citizen who's age 21 and older. Dear attorney, since VAWA is heavily relied on self-declaration, of course, marriage is bona fide and immigration isn't and immigration isn't allowed to contact the abuser. How does USCIS consider I-360 proceeding with truth? So they are going to evaluate the evidence to determine whether it's credible. That's what it means by you have to present any credible evidence. And this is why it's very important for us to present credible information. That's why the declaration is not, you can't write a paragraph saying, I was abused by my spouse. They treated me very badly. I wanted a divorce because they treated me very badly. That declaration has to be a lot more detailed than that. You give dates, you give events, you give incidents, you give timelines, you give routines about your marriage, you talk about specific acts against you. this is what's going to make it credible evidence that will be accepted by immigration. Because if it does have and they do evaluate this very carefully to see if there are any contradictions in your statement, if there's contradictions in the evidence presented, to determine whether it's credible or not. How long does it take from time you got your green card to apply for citizenship? 3 years if you're married to a US citizen, um, 5 years in any other way if you're in the military, 1 year, I believe 1 year during peacetime, 6 months during the wartime. Hi there. Hi, Anna Gay. Hi, Diana. It's nice to see you. All right. It's been 9 months since we filed I-130 for spouse of US citizen, still not approved. How long? So for the I-130, 9 months to 12 months. So you're still within that processing time. Hello, I want you to help me file my asylum. Give us a call. This is exactly what we do. I need to evaluate first that you qualify for asylum, and then we get started. If H4 don't want to file green card, still is he eligible for filing EAD? So H4 is usually the spouse of or child of an H1B holder. Now, in this case, if you qualify, it just depends on what your circumstances are, what the circumstances are of your relatives. So that's where we need to talk. Do I have to send I-601 with I-485? I legally entered with F1 visa, this is where you need to get legal advice, because the I-601, it depends on what you're applying for. But if you're applying for family-based immigration, you enter the country legally and you qualify for adjustment of status, and say you're the immediate relative of a US citizen, you don't need an I-601. But do not take this as confirmation that you don't need any of those. What I am saying, though, is that you may be misunderstanding the process, and this is where it's so important to get legal advice. So you're not filing unnecessary forms or wrong forms here. So give me a call, schedule an appointment. Does an asylum seeker change his status to H1 work visa? So this is tricky because when you, as an asylum seeker, you are in a gray area where you don't officially have when you haven't been approved for asylum yet, right? But you have your work permit, you have your social. You are not in status. You don't have any particular status right now. So you would not be able to change status to a work visa because you're in this gray area. Now, this may be subject to case law analysis. I'm pretty sure this might be something that's discussed in case law. So it does require a lot more research here. But generally, the last time I checked, being an asylum seeker kind of puts you in a gray area where you can't just jump to apply for a work visa, or employer can't apply for you because you're in this gray area where you don't have status, but you do have some permission to be here while your process is going forward. I'm deported for over 19 years. Can I apply for a US visa, or do I need to file a petition? So if you have been deported, they do have certain requirements that you stay out of the country for a certain number of years before you even try to apply to come back. But whether you're deported, but for what reason, that's what tells me whether or not you can just apply for a US visa, or do you need a waiver to go with that. So it's complex. That's where talk to us. Let's schedule an appointment. My cousin came here as a college J1 student, and she's overstayed due to a threatening situation back home as she fears for her life. Is there a way which she can apply for a work permit? So if she is in fear of returning to her country because she's being threatened based on her identity, based on, and when I say identity, she's a part of a group that's being targeted, or based on religion, politics, maybe her opinion. So remember too, political opinion does not necessarily mean that she has to be with, so if this is Jamaica, I don't know if this is Jamaica, or another country. But it, for example, in certain countries you have political parties. It doesn't mean that you're aligned with one party, so they're going after you for being aligned to a political party. Based on your being threatened based on your political opinion could be maybe you oppose gangs and you are fighting, advocating against gangs or expressing your opinion against gangs, and because of that you're being targeted and not protected by the government. That can also be a type of political opinion. Does testament alone qualify for a VAWA? I think you mean, does like a declaration alone qualify? So it may, it just depends on what your circumstances are. This is where the evaluation is very important. Hello, it's been 9. So I answered that about the I-130. Based on my experience, I've seen about 9 to 12 months. Is there a short chance of getting I-601 waiver fraud, Mr.? There's no, it's not. This is discretionary, and it really depends on what the case, what's going on in your case, and the content of your waiver is very involved. There's a lot of preparation that has to go into it. And for example, when I'm working on it, I do have to present legal arguments, explaining why my client qualifies for the I-601 waiver approval. So it's not guaranteed. Um, my ex emotionally damaged me, threatened to have me deported. Does that qualify for VAWA? Is it your ex-spouse? If you've been married, if you've been divorced for less than 2 years, the VAWA is it here. Of course, we still have to talk about it to confirm, because I'm not your attorney. I haven't had a discussion with you. Now, if this was not your spouse, but they put you through this as well, I'd want to learn more to see if you have alternative options available, like the T status. So schedule an appointment. Let's talk about it and figure out what can work here. Are they still waiving the I-485 interview? So yes, I haven't heard any different. And I am getting those waived interviews coming in. What if you stay over your time? How do you get your stay? How you get your stay? So extension, you have to apply for extension, but you can't overstay first. But they just released regulations saying that if you can make an argument as to why you missed the deadline to apply for an extension, they will still grant you an extension. So that would be one way. If you overstay, though, there's a risk that you can't fix that. I'm curious and want to know what the end result of our case. Say you get approved, can you get a U.S. citizenship through approved VAWA? Approved VAWA means you get the green card next, and then you become a citizen afterwards. You can apply for citizenship afterwards. I have green card, 2 months. I entered the USA, but went back to Africa a month ago. How long can I stay outside of the country with no issue? So I would say don't stay outside of the country more than 6 months. I'm going to need you as a lawyer. Go ahead, schedule an appointment. First, let's talk, and then I'll be more than happy to assist you should you qualify. My family has been approved for asylum, and me and my son has a green card. Congratulations, but my son came on C1D. Can we apply for citizenship? So you have been approved for green card. Me and my son have a green card, but my husband came. So if your husband did not get asylum, so another thing here is we have to talk, because the spouse usually can get asylum with you. If you got married after, though, you got asylum, your spouse came on a C1D, they may be out of luck here. Now, the C1D, by the way, is a crewman's visa. If you work on the ship or work on the airline, work on the plane, and you come in on that work visa, the C1D that allows you to transit through the US, if you overstay, then they do not allow you to adjust status. But under VAWA, they do. So if you're being mistreated by a spouse, they will still allow you to do that even though you overstayed. But any other case, it's very restrictive and it can prevent you from um, getting a adjustment of status. Now, if your spouse got the asylum with you, but initially had come in on the C1D, but they have their green card along with you, then it should, once they have their green card, the C1D visa is not going to stop them from getting citizenship, or should not stop them. Can I take someone off my affidavit of support? So once you sign that, it's a contract for the next 10 years. So if you're talking about, if you're the sponsor, and you signed it, sent it in, there's no, stopping that from going forward. If you want to take comfort, even though they do enforce it, the government does enforce affidavits sometimes. If it's any comfort, it's very rare that they enforce that affidavit of support, where they, go after the person who signed the sponsorship form. So that may be it doesn't mean guarantee that you won't be, but it's something that's not common. Okay, can I do an I-130 for my mom? I'm a US citizen. She left 13 years ago. Okay, so I answered that. Can I still adjust status if my F1 visa expires? I'm currently waiting for perm approval. So if you applied for perm, so this is employment based, before your F1 visa expired and you have a pending adjustment of status application, as long as you applied before and you have a current priority date and you meet all the requirements, then it shouldn't be a problem. Where it would be a problem though is if that perm gets denied. Okay. So let me backtrack here. So the perm is when you're applying to Department of Labor. So let me backtrack and correct that. You're applying to the Department of Labor. That's not the immigration yet. You have to get that approved first. Then you can file the adjustment of status. If you file the perm and while the perm is pending, you overstay, you cannot file the adjustment of status application, because it is the adjustment of status application that where you have to make sure that you are in status when you're applying for it under employment-based processes. There are certain exceptions here, certain exceptions when you are out of status for a certain number of days. They may still allow you to move forward with this, but it's risky. So this is where it's so important to get legal advice, because it may not work depending on that overstay. VAWA I-485 got denied. I entered without inspection before 5-year ban. I appealed. So yeah, you have a complex issue there. We definitely would have to talk in a consultation. So how can I get a work permit? If you've been following me, you know that all I talk about at the end of the day are work permits. But what I talk about are the ways to get to the work permit, and the ways to get to the work permit does take some hard work here, and it does mean that you do have to qualify. So follow me, and you will learn the ways. You can go back into my videos, and you will definitely learn those ways on how to get the work permit. It's not something I can break down in 5 minutes, unfortunately, and maybe fortunately, because there are multiple options for that. So follow me and learn. How can you get temporary green card to be able to join the military? There's no such thing as a temporary green card. There's what's called conditional green card for those spouses of citizens or residents who are married for less than 2 years. They get a temporary conditional green card that's for 2 years. Maybe you can join at that point, but unfortunately, you will not be you can't get a temporary green card to join the military. Can I get under VAWA? Can I get under VAWA if I have never married but lived as being married? If your marriage is considered a common law under state law. So if you're in a state that recognizes common law, which is a minority of states that do, but if you are, then yes, you could apply as a common law couple. But there are alternatives here. If you're mistreated by someone you are living with, then we can talk about alternatives, for example, like the T status, depending on what occurred, may be an option here. So give me a call. Let's talk. All right. That's going to be it for me today. What I'm going to do is um, I'm going to see you on Monday. And hopefully I can make it at lunchtime. So I usually come on at lunchtime. So please join me on Monday. Look out for me. The best thing you can do, follow me, and then um, follow me, and then you'll see when I join, which should be between 12 and 1. And when I join me on the live and come with your questions. Hi there, Donna. Thanks so much. I appreciate that. All right. So thanks everyone for your time. I appreciate it. Follow me, join me when I come on, on YouTube. Make sure you subscribe. You'll get notifications when I go live. Same on TikTok and on Instagram. All right. Thanks so much, everyone. If I didn't get to your questions, save them and then we can talk about your questions on Monday. Have a good weekend. Bye bye.